May it please the court, I'm David Domina. I'm here on behalf of Steve Howard and his law firm. I represent them on this appeal. I want to start with a question of jurisdiction, and I'd like to cover some facts by way of background. Master Blaster Inc. is a Nebraska corporation. David Lerette owned it. He was its president. Master Blaster sold its assets and took back a promissory note. The purchaser was a man named Anderson. Anderson didn't pay the note. Master Blaster went to court, sued, won a judgment. The judgment was appealed. The Court of Appeals affirmed Master Blaster's judgment against Anderson. That appeal was decided in case number 09353 by the Court of Appeals in an unpublished opinion. When this case started, David Lerette filed suit as plaintiff. Master Blaster did not file suit.
Counsel, I have a question about that very premise.
Yes, sir. Yes, ma'am.
That's all right. I've been called worse.
Well, I apologize.
When I look at the pleadings in this case, it's unclear to me whether there is one plaintiff or two. And I noticed that sometimes it's referred to as plaintiffs, Lerette and Master Blaster, and in some of the certificates of service and things like that, both of them are served separately. And so it's just not clear to me whether Master Blaster is one of the plaintiffs or not.
I have two answers, Your Honor. The first is to refer you to the original pleading, which says that David Lerette is the plaintiff and owner of Master Blaster. But it does not say Master Blaster is a plaintiff. It doesn't claim that Master Blaster seeks a judgment. The second is that when the case was submitted to the jury, it was submitted only as Mr. Lerette's case. The jury was only given an opportunity to return a judgment in favor of Lerette. There was no submission on behalf of Master Blaster. So at the beginning and at the end, I think Master Blaster was the real party in interest, but Lerette was the plaintiff.
What about the caption of the operative complaint? Was it like the second amended complaint or something?
Well, there was a second amended complaint that changed the caption a little bit, but not the text, and didn't change the parties. There was never an order allowing a substitution or addition of parties at that time. The case proceeded with one plaintiff. There was sloppiness, if I may respectfully call it that, by the practitioners involved here at not cleaning that up and making it abundantly clear. But the trial court understood it and submitted the case only on behalf of Mr. Lerette. And I think that is determinative. Jurisdiction had to exist on day one. Standing had to exist on day one. Standing is judged from the complaint. And the complaint says it was brought on behalf of David Lerette, who owned Master Blaster. Master Blaster was the real party in interest. There's no evidence anywhere in the record of any assignment of Master Blaster's claim. That would have been permissible. There certainly is no permission to assign Master Blaster's second claim, which is for malpractice against my client. The first claim on the promissory note could have been assigned by Master Blaster to Lerette, but that was never proven. The second claim is not assignable. So all of that leaves us in a situation where this case proceeded all the way through the legal process to this morning with the wrong party as the plaintiff. The real party in interest did not bring this suit. That was the corporation. For that reason, we think the case should be dismissed. Now, for the sake of argument, I will be brief about the two errors assigned by the appellant. First, the argument that the trial court incorrectly reduced the amount of the judgment is fact-intensive. And as Judge Steinke inquired, is there any evidence in the record to suggest that $350,000 was an unreasonable settlement or that there was more money to get that should have been obtainable? There was no expert testimony on that point. Mr. Laughlin didn't so testify. No expert so testified. And to demystify what the mediator did in mediation, I would say two things. Number one, settlement talk isn't ordinarily evidence. Number two, the mediator was actually trying to get everybody in the room to compromise, to bring peace to the world and not to decide a legal issue. So I don't think Mr. Mullen's a great mediator, but what he did to try to mediate isn't good evidence. On the sanctions issue...
but it is evidence. It is in the record, is it not?
It is evidence. It is in the record. I don't think there were good objections to it. I just don't think it's compelling, Your Honor. And I don't think it overcomes the absence of evidence about whether $350 was a reasonable number at which to settle. And if it was a reasonable number, it doesn't have to be the best number. It doesn't have to be what the claim was. The obligation, of course, here was to prove what was reasonably recoverable.
Is a mediator...
What about the $1 million fee?
Well, that was a demand, and as you have said in some of your previous decisions, a malpractice claim recovery is limited to what is available from the underlying tortfeasor. You don't improve your hold, to use that old language, by suing the lawyer. So the amount of the demand is not a measure of the claim. And I would, again, acknowledge that the amount of the demand was in the evidence, but it's not proof of what's recoverable.
What's the significance of the mediator's numbers? Would the mediator be considered somebody expert in the field?
Expert at mediation, yes, Your Honor. Expert at valuing the claim, no. And let me bring that slightly to life. The mediator's job is to find that crevice between the parties where they can settle into an agreement that nobody likes. It has nothing to do with deciding legal issues. And so here, what the mediator was doing, a good mediator always does, is take the temperature in the room, assess the emotions, assess the facts, assess the arguments, assess the skills, and try to find that crevice. Now, Mr. Mullen's a master at that. But that has nothing to do with valuing legal claims as an expert called upon to perform a valuation service. It's a completely different skill.
So what is the significance of the settlement amount? Does that have any significance?
Yes, I think there is significance in the settlement amount, Your Honor, and that significance is, number one, there was a settlement. Number two, it was agreed to by the debtor, who, Mr. Anderson here, who owed the debt to Master Blaster.
But not agreed to by Lerette.
It was not agreed to by Lerette, but Lerette wasn't a party to what was being settled that day. Only Anderson was. It was his claim to settle. And number three, we're talking about a bankruptcy malpractice claim that could have involved a bankruptcy discharge, and you get half. It doesn't sound so bad to me.
As opposed to a discharge?
Yes, that's correct. So I think that the appellant's first assignment of error, fact-intensive, isn't supported by facts. And on the question of sanctions, it's certainly true that Section 25824 doesn't authorize sanctions for discovery infractions. This Court has never suggested that the discovery rules can be applied post-judgment. I think there is, with all due respect, some excessive expression of the facts in how egregious this case was. There were legal issues that were raised because there were two different clients who were claimed to be represented, and that did confuse the discovery. And there was never a suggestion that those discovery motions and delays were bad faith acts.
In granting, in part, the motion for judgment notwithstanding the verdict, Judge Burns reduced the jury verdict to the settlement awarded in Anderson's case against his bankruptcy lawyers, $350,000, less an attorney fee for Mr. Howard of, I believe it was $114,000. How should this court reconcile that with precedent to the effect that when an attorney enters into representation where there's a conflict of interest, he or she is not entitled to an award of an attorney fee?
Well, Your Honor, you've clearly held that when the rules of professional conduct are violated, you can't be earning a fee during the period of violation. I recognize and respect that rule. In this case, this being a tort case, there being no predicate that is dependent entirely for the malpractice on anything other than mishandling the claim against the bankruptcy lawyers, and then separately failing to account to Lerette for the money, it isn't a conflict that is the alleged operative fact. It's the failure to account for the money that Lerette claims he was entitled to under what he alleges was an attorney-client relationship. So I if there's a distinction, and I think there is, then I think the distinction is that this claim and judgment don't spring from an allegation that the Malpractice Act was a violation of the rules of professional conduct.
The
Thank you
jury
very
found there was a conflict of interest.
much.
Or did they find that there was dual representation? Did they have to find that to give the judgment they gave?
I don't think so. As I recall the instructions, that wasn't one of the elements of proof that was required, so I think the answer based on the instructions is no, Your Honor.
So under what theory does Lerette receive a judgment?
Well, I think step one of the theory is that he was accepted without challenge as a surrogate for Master Blaster, and number two, the thought was that the total amount owed Master Blaster was still $460,000 plus interest, and that brought the total, when calculated by Dr. Sherman, the expert, to $775,000.
Why would Howard owe money to Lerette or Master Blaster? Under
Well,
what theory?
There was never a claim he was hired by Master Blaster. There was a claim he was hired by Lerette.
Correct.
And the theory Lerette had was that Howard was hired by Lerette to collect money to Anderson as Lerette's surrogate to be paid to Anderson. Now, that's mighty close to a conflict of interest.
Well, the jury awards him money under some theory of a cause of action. And so that would,
And I think that theory is a direct contractual responsibility between Lerette as client and Howard as lawyer. I think that's how it was instructed. Now, whether it could or should have been instructed that way is a different matter. I think much of that would have been resolved if the real party and interest issue would have been raised timely, but it wasn't.
Actually, I think the jury may have been instructed on conflict of interest, but
I don't
I'll have
remember,
to check.
so I stand corrected. I want to hesitate on that. I'm not certain.
Okay.
thank you.
Thank you.